I take, I take to heart what Mr. Nagel presented in his sentencing statement, which we are only here to address the 2 counts of endangerment with a controlled substance. It would be ridiculous to ignore that we have other things at play here. However, this court has no role in investigating other matters, in making any kind of a prejudgment. I have no idea what happened in the other case, whether that will come before this court or whether Ms. Bowers is responsible. That is for another day and another time. I am only addressing the 2 children at issue here, JWC and DEC. When I handled Ms. Bowers and Mr. Carlson's first appearances, and I made it clear at that time that I was only considering the information that has to do with what's before me today, and that's what's appropriate. That being said, the statute at issue here does not require that Ms. Bowers is the one that is using the methamphetamine. What it requires is that she allowed her children to be exposed to methamphetamine. And by the evidence before this court and the evidence that she's agreed the court can consider, it is clear that she's responsible. And I said something along the same lines to Mr. Carlson. It is a parent's job to protect their children, and Ms. Bowers failed to do that. And in the end, I don't really care who used the methamphetamine. I am convinced beyond any doubt that they both knew that their children were being exposed and they took no steps to stop it. So then the question is, where, in what is a fairly small standard range, 15 to 20 months, do I sentence Ms. Bowers? And I simply cannot sentence her to the bottom of the range. She is not sort of the usual addict that would come before the court. She had the benefit of completing a residential DOSA and the treatment that came in her prior dependency. So she certainly had the tools, which she simply chose not to employ, to not use or not protect. She's well aware of the danger that methamphetamine poses. And these children are exceptionally vulnerable. You have a 6-year-old who has major medical issues and is not capable of protecting themselves, and a child who's only 2 years old. While a sentence of 15 months would be commensurate with what Mr. Carlson got, it would only be a 3-month difference, and that's not enough considering Ms. Bowers' additional criminal history. So the top of the standard range is the appropriate sentence, 20 months in prison on each count. By law, they must run at the same time, restitution to be determined. I find Ms. Bowers indigent for purposes of sentencing, so legal financial obligations will be limited to the mandatory assessment. I do want a condition in there that she will have no unsupervised contact with non-biological children. Any contact she may in the future have with her biological children will be governed by the court and the dependency matters. Mr. Walker, is there anything else that the court needs to address?
Well, is the court making a finding that a chemical dependency contributed to the offense?
Yes.
Your Honor, when you say non-biological children, you mean anyone under the age of 18?
Yes.
Okay.
And you may specify that if you wish, so there's no confusion. I'm not saying that she can't be at a family function where there's children, but she shall not be the supervisor of those children. There will be a responsible adult there to take care of them. Okay. Anything else, Mr. Nagel, that needs to be clarified?
No.
All right, then once you have gone over the judgment and sentence with your client and obtained her fingerprints in front of the clerk, I will sign that, and Ms. Bowers will be remanded to the Department of Corrections.